Oh, that. Right, good evening, everybody. I think we might as well launch this particular boat. I'd like to thank you all for coming for this first licensing meeting of the current local year, and I'd also like to thank the portfolio holder for coming to attend this meeting, which is always helpful sometimes to have the portfolio holder present. If I may, I'll just read the fire evacuation procedures. There are no fire alarms scheduled for this evening. Therefore, if a fire alarm sounds, we'll evacuate the building immediately. The fire exit is located at the rear of this room, down the stairs, and meet in the War Memorial Park. Thank you for that. Apologies for absence and substitutions. Are you in charge of that? No? Apparently not.
It's on the sheet.
Oh, sorry, is it? I don't see any sheet.
There was a sheet.
Well, anyway,
I'll tell you.
no, that's not it, is it? Oh, is it right? Councillor Laura Edwards is replaced by Councillor Mumalania. Apologies also from Councillor Durant and also from Councillor S. Jeans. Everybody's sadly gone down with COVID. So we'll go on. Has anybody wish to make any declarations of interest? No? Thank you very much. We now come to appointment of vice chair. I have had a word with legal, and it is in order, apparently, for us, to, if we wish to do so, to nominate, second, and elect a member who's not actually present because they're down with COVID. So I would like to nominate Councillor S. Jeans. Does anybody wish to second that? Councillor Taylor will second that. Thank you very much. Are there any other nominations? Right, and may we have a seconder for Councillor Phillimore? Right, thank you very much. Okay, so that leaves, we've got two nominations, so can we start by asking for hands up for those who wish to support Councillor Jeans? Five, thank you very much. And that leaves Councillor Phillimore with 4. Thank you very much. So by a narrow margin, Councillor Jeans is elected. Thank you very much. So now we'll go on to, I've already lost a bit of paper. Urgent matters, there are no urgent matters. Minutes of the meeting held on March the 28th. Which you have in your papers. Has anybody wished to raise any points, any issues with those minutes? No? So I'll sign them at the end of the meeting if I may. And then we also have the minutes for the meeting on the 4th of May, 2022. Does anybody have any comments to make there? No? Right, we'll sign those at the end. So that brings us on to item 6, approval for adoption of the Shared Licensing Service Statement of Licensing Policy 2003 following consultation. Can I just mention at this point that a couple of people have indicated to me that they have suffered some slight confusion about whether we are a single licensing authority or whether we're a split double licensing authority, because this has in their view raised a number of occasions in the papers here where there is confusion about the singular or plural terms being used. And I might add that as having some experience of legal matters, I would point out that if decisions made by the licensing subcommittees are or were to be appealed for any reason whatsoever, then it's vitally important that barristers will leap on the exact phraseology used to try and illustrate the case that they want to prove. So it is very, very important that the document is very professional and totally and completely accurate. Now, I think at some point we perhaps might have a discussion as to whether the committee want to do anything about that, or whether they wish to just leave the terminology exactly as it is. But we can deal with that later. So we are now, would you like to?
Yes.
Thank you.
Okay, good evening. So the first paper that's been brought to Licensing Committee this evening is for the approval of the Licensing Act Statement of Policy to go to full council for adoption. The Licensing Act Statement of Policy is the policy that defines the regime that both officers and this committee need to work to under the Licensing Act 2003. As part of that Act, we are required every 5 years to review the policy, and this is the end of that process. It has been out for its 12-week public consultation, been to the responsible authorities, that includes police, fire, trading standards and another number of other authorities. It also was shared with all of our licence holders, but there was no actual change to the Basingstoke content apart from the fact that it became a shared service policy. As a licensing team, we are a shared service, so we work for both Basingstoke and for Herts. As a licensing committee, there are two. So there is a Basingstoke licensing committee that can make amendments to the Basingstoke parts of the policy, and a Hert licensing committee that can make amendments to the Hert parts of the policy. There are two separate licensing authorities that have a joint service that support them, in answer to the question that was raised. During the public consultation, which closed in February, we received two representations, one from the police and one from a public body. Both of these were responded to at the time that we had them, and in Appendix A it can show the comments that were made and the responses that were sent out. Only one amendment to the policy was made, and that was to the second consultation at point 2310, where protection for sexual harassment was added to the list of preventions. The consultation response from the police, so we work very closely in partnership with Hampshire Police, and you may have seen the press release on the 12th of May. A lot of what they're discussing here, we are already doing with them, promoting welfare officers within the nighttime economy to protect the people that go out. Specifically, protection for women, there is Ask for Angela that is promoted at our venues. Ask for Angela, if you are unaware of that, it's a national campaign that if you are a single female and you feel worried in any point, you can go to the bar or to a bar bouncer and you will ask if Angela is working, and then they will know that you need help. Hampshire Police are rolling out training throughout the rest of the year to encourage the welfare officers for venues that haven't taken this up yet, and to promote that actually everybody in our nighttime economy needs to be protected. So our recommendation for this is that it is approved and taken to full council for adoption.
Thank you very much. So we've got two alternatives. I mean, I don't need to add all those people who members of this committee last year will be aware that, except for the one exception mentioned, this document is more or less an exact reproduction of the document which was passed by full council last year for this committee. So our two alternatives. So either accept the document as it currently stands, or if anybody wishes to raise any suggestions, queries, then and possibly amendments or alterations, now is the time to do it. So the two alternatives are either to treat the whole document as one entity here now, or if the committee feel it useful and necessary to do so, to go through it, as it were, piece by piece, and then everybody can raise any queries they have in each particular section as we arrive at it. I don't know whether the committee feels that they know enough about it just to say yay or nay to it as it stands, or whether they'd like to go through it in more detail. Can I ask would the committee like us to go through this document in more detail? No? Right. Well, in that case, can I ask if anybody wishes to raise any matters, make any comments in general? Thank you.
No, it's only a quick one. I'm quite happy with the policy. Do we know what the savings are by having a joint licensing thing with Hart? Do we, does anybody know what the savings are? Because that's the idea of it, as I understood it. It'd be nice to know if we are saving money or not.
The exact savings is something that I'd have to find out for you, but all shared services, because you share the staff between two authorities, it makes us more resilient. Instead of having to apply and have within Basingstoke the staff that we have here, we can move them between the two. So there are savings, but that is something that I would need to get and be able to bring back to the committee for you, the exact numbers.
It'd be nice to know because, and secondly, I think, has it got any detrimental effects concerning not having officers on the site and everything else, not for us, for the public when they apply and things like that? Whether it has or not, I don't know. I'm just asking the question of whether you've got anything.
I hope it's okay if I respond. Obviously, the portfolio is new to me, as I'm sure you're aware. So your questions are totally, if we can take them away. Obviously, I don't think they're strictly relevant to this paper, but I agree with you. It might be helpful to understand a bit of the context around the shared service. And for me, it's not just around the savings. I assume there must have been some, but actually in terms of the services as well, is it performing as we would expect it to be? So again, new portfolio, it'd be good to understand what the KPIs are and how we're performing against those, because I would expect as a minimum there shouldn't have been any degradation to the service, for example. So I think they're things that we can definitely take away and come back to you on.
Do we have any more? Councillor Taylor.
Could I just ask a question? On page 38, it talks about 13.3. It says that if a matter to be decided is controversial in any way, or the determination of the matter under delegated powers is precluded by law, then it will be decided by the full council or licensing committee or subcommittee as appropriate. And I notice at Appendix B, it really just says the only thing that's referred to full council is the licensing policy itself. Do we have any mechanism whereby we can decide if an issue is being discussed is serious enough or far-reaching enough for it to actually be decided by the full council and bypass the committee?
Yeah, the full council involvement is the approval of the licensing committee. So it's prescribed under the Licensing Act and the regulations about what goes through licensing subcommittee. which will be decisions, let's say, if there's a review or if there's objections against a new application. So that potentially could be, maybe it's not as clear in 13.3 as it could be. Licensing subcommittee decisions are then subject to appeal rights to magistrates' court as opposed to higher up in the council framework. So it is only the licensing policy which is subject to approval from the full council.
So I'm just trying to think, we're sort of, somebody, it was Robert who described us as a backwater, which was a bit rude last time. But if, for instance, there was something big suddenly happening in Basingstoke, like a massive great mecca casino was going to be considered, and that's big, that affects the entire borough, really. Is that something where we could say it is appropriate to give this to full council and not just to the licensing committee?
In that example, it would be subject to the Gambling Act policy. But if it was a mega nightclub that came here, then it still would be subject to the same procedures under the Licensing Act, which is prescribed in law. So it would come through officers, subject to statutory consultation, in which is public consultation. We go to responsible authorities, and anybody can object against any application as long as it's relevant to the licensing objectives. If we get representations, then the next stage, and the only stage that the council would be involved in, is subcommittee hearing, and then obviously they have regards to the licensing policy that we've got in place, and then the appeal right is to the magistrates' court, not full council. So it is subject to wide consultation, but it's not something that would go to. I mean, they'd have to get presumably planning applications and things through other departments as well. But from a licensing perspective, it would just be through the licensing team, meets the advertising regulations. We go through the application process and then go to subcommittee if we have relevant objections.
Thanks, Chair. Without being a nitpicker, can I refer you to page 49, which is 2321, conditions to promote the prevention of public nuisance. And it says there, the applicant will be expected to demonstrate they have considered the following and included steps to prevent public nuisance. Can someone tell me how an applicant can control the availability of public transport to and from their premises?
Well, I mean, there are steps that they can do, because if they're obviously going to have, let's say, something like Car Fest, for instance, at Laverstoke Park, it's in the middle of nowhere. They have arrangements on site to provide taxi pickup and collections. They have pre-bookable lines. They've increased their mobile phone signals so that people can book taxis from there. You're right, it has no influence over public transport, but there are steps that they can put in place to try to aid dispersal. And
I think the word public's wrong.
yeah.
I think the word public wrong.
Okay.
Use it the mole at Monk Shirburn or the Power at Little Lane.
The requirement from the policy is that they have they considered the following and included steps to prevent public nuisance. So that takes into account that public transport to and from the policy. If there is none, then can they offer anything else as a suitable alternative? Or, I'm trying to think of reasonable steps really. What we've got at Carfest has improved over years, where they have allowed taxi offices on site, so people actually will walk to a desk and actually book taxis.
Oh, sorry, is it you? Beg your pardon. After you.
Thank you very much, Chair. I just wanted to ask you, there's a, on page 50, 23.24 and 23.25, it says there's steps to prevent children been harmed, etc. What is concerning is like some of the kids basically in the early teens and they get fake ID and some of them look older than their age. How are you going to prevent all that happening? Is there going to be stricter policies or something on top of this to protect kids? Because if it's at all entertainment or anything else, they shouldn't really be in those premises, and that's what I'm worried about, them getting fake IDs and getting in, which I know that there's been a problem in the past in Basingstoke and Dean.
Yeah, so the Licensing Act isn't obviously to prevent minors getting into pubs, because well-run family pubs encourage families to go into licensed premises. The high-risk nighttime economy, yes, we expect for applications to include measures to how they're going to ensure that minors don't get into licensed premises. When we do our compliance inspections, we are aware that they the security staff do refuse entry. They keep records of who they refuse entry and why they refuse entry, whether it be to their age or intoxication levels. They also confiscate a lot of fake ID, which they then provide to the police licensing officers. So it tends to be, yes, more in place. So they will have SIA security on the doors at late night places. They will do their checks. They have to have a mandatory age verification policy. We push for Challenge 25. Most of the town centre late night premises do have Challenge 25, if not Challenge 21. But yeah, those are the premises that they are looking to put measures in place to make sure that minors don't get in. Obviously, a lot of licences, they are all individual premises licences, big spoke to their own pubs, but some do prohibit, children after 7 p.m. Others, so long as they've got a responsible adult with them. But if there are issues, then we would certainly work with the police to tighten up on those issues. If it needs to be, then we can work with them to put individual conditions on the licence to address that.
Any further comments? Questions? Councillor Taylor?
Could I just ask, having looked through it, it's obviously fairly familiar. Apart from the added clause, which was very welcome, are there any broad differences between this one and the previous one that we need to note?
No, the added clause is the only difference to the Basingstoke previous policy.
No further questions, comments? No? Oh, sorry, Councillor Taylor again.
Is it time now to revert to the to the grammar thing? I just find it very confusing, and I don't blame everyone for finding it confusing themselves, because it's really difficult to write a coherent policy when you're talking about two completely different areas and authorities. Can I just check, first of all, we're a shared licensing service. Are we two adjacent licensing authorities, BDBC and Hart District Council, or is it a joint statement made by the licensing authority which incorporates both Basingstoke and Hart?
It's a joint statement for the licensing service which incorporates two separate entities which are two different licensing authorities. So Basingstoke and Hart. So we as the shared service are one entity who deliver that service to two licensing authorities.
Right. In that case, can we get it so it reads right, basically? In some places we talk about, well, for instance, I don't want to be critical in any way because I know how difficult this is, but just for, even the first paragraph doesn't quite make sense. But if we go to, for instance, paragraph 5 at 5.6, it talks about the licensing authorities, plural. But then at 5.7, it talks about the licensing authority, singular. At 5.8, it says the licensing authority's aims, which is a mix of singular and plural. Would it work? We've either got to pick one or the other. We've either got to talk about two authorities and make it plural, or one authority and explain why we're talking about one authority. Would it work, though, to do what I noticed that you've done with the next one that we're going to talk, which is the charities collection one, where you talk about the single entity, which is the shared licensing service? Can we use that phrase in this one so that we can more or less make it read very much like it did before, all in the singular, understanding that we're talking about both at the same time? Obviously, there are one or two places where we have to separate. Now we're talking about Basingstoke, now we're talking about Hart. But would it work to talk about the SLS rather than either the licensing authority or authorities or councils or council? Would that read right as a policy statement?
Yes, we can certainly change it to the shared licensing service and make an amendment at the top so it's clear that it's a shared licensing service that supports two separate licensing authorities.
But what I mean is, throughout the whole thing, where you talk about licensing authorities, change it to SLS. I know it's a lot of work, but, you know, as Councillor Godison said, if we're going to be in front of magistrates or even worse, barristers, or even worse, QCs, it's really got to, you know, I've been belittled by too many of these barristers before. I don't want it to happen again. So if we could do that, that would be excellent. Thank you.
Councillor Hussey.
Why can't we have a glossary of terms defined and then those definitions apply throughout the paper? So that would bring consistency of definition.
You can. We can add that in for you.
Good, thank you very much. So am I to understand that with those provisos as just raised now by the two councillors, we are happy to pass this document and pass it on to the Cabinet and full Council? Thank you very much. Now we move on to item 7, review of shared service charity street collection policy. Over to you.
Okay, so again, this was last reviewed 5 years ago. So we're just merging it into a shared service policy to provide business continuity across the licensing shared service. Again, there are no changes to the Basingstoke content within this policy, apart from at point 423 on page 77, where the card payment protection details have been updated to the latest version. We don't actually get any fees for charity collections. We have no authorisation over those that are in the shopping centres, which is inside the policy. So we only authorise those that do street collections, so like at the top of town and the other areas throughout the authority. During COVID, charities were unable to do any sort of collections, so we've had an increase on the amount of charity collections that we've had so far this year at 21. There's usually 1 or 2 a month, but they're trying to recoup the money that they lost during COVID, which is understandable. So we're asking for this document to go out to public consultation, which will apply best practice standards to. So it will be out for 12 weeks, closing in September. It will also go to the responsible authorities and to the major charities that we provide charity collection licences for. So this is all done under the Police Factories Miscellaneous Act 1916. So it's a nice modern piece of legislation that we have for this one. And there's been no legislation changes that have been added to this policy either.
Thank you very much. Any comments, suggestions, questions? Councillor?
Thank you, Chair. I'm a little bit concerned about some areas. I know you said we don't permit any collection in private shopping centres like Festival Place, and malls, don't you think there should be a case where we should be doing that? Because I know that they have strict regulations probably as well, the actual people that own these malls, etc. But at the same time, I'm worried about fraud as well. Someone could be there, sort of saying they're collecting for charity, and it could be a fraud in one of those. Isn't there a way we can sort of work with them and sort of give a joint permission rather than them only giving it, sort of thing?
The very short answer to that is no. We don't have any jurisdiction because they're privately owned. They have a management company that manages it, and we don't deal with any of the complaints that come from within those privately owned entities. But if there are any complaints of frauds of anywhere outside, then Andy and the officers would deal with them.
Right, okay, so the reason why I asked that question is because of the impression the public may have. So it'll come to us when they would have that impression that it's us sort of basically giving them the permission sort of thing. So I know you've said it's privately owned, but what I'm trying to say is can't we build a relationship with them to know who's collecting and who isn't collecting, why they're collecting, etc.? Or is it a case where, okay, they are owned by pension funds or whatever, and they've got a committee, and they're the only ones who can actually, as you mentioned, can do that? I'm trying to sort of say, can we have a bridge between us and them, sort of thing?
We do have a relationship with their management, but not to that level where they would tell us every collection that they're having. I know when I go down at lunchtimes, there is always somebody collecting, and it's their responsibility because under the Act and the Charities Act 1992, we just don't have any authority to get involved on things that are on private land, but we do have a good relationship with them.
Any more questions? No, Councillor Taylor, thank you.
Thank you very much. If I could just, paragraph 420, which refers, I believe, to collections in the towns. I think that's right, isn't it? That section about collections in towns. There's a list of reasons to refuse an application, and that's very good. But there's 6 reasons, and I can't imagine that they're exhaustive. Is it possible to put in another one which says something like, or any further reason deemed appropriate for refusal, or something which gives us a way in which we can exercise some of our own discretion? Because I'm sure there must be other reasons that we haven't got listed in 6 here. Is it possible to slip something like that in? I mean, we do say, for instance, it can be revoked after issue for any of the above or other relevant reasons. So if we could have the or other relevant reason in the first one.
Yeah, I think that's a good idea, and it is captured under other licensing acts, as you know. Any other reasonable cause, if it's appropriate and it's reasonable, then absolutely. So yeah, I think that's a good suggestion.
Yeah, it'd be nice to know how many of these collections are done over a yearly thing and what complaints you would get. It'd be nice to have a report once a year or whatever, just to see how things are going. Because we're only talking really at the top of town, aren't we, in general terms? I believe, I know he's not going to festival place isn't ours, but I don't know about the other side, which we part own. Do we have collectors there?
We get them throughout the district, councillor. So you get them, especially at obviously Christmas time and things where clubs want to do their own charity collections. So it's all over. It can be in village centres where they're looking to raise funds. We can do. We can produce a report and let you know what the statistics are. The majority of them do take place in supermarket foyers when you walk in and out of supermarkets and in festival places. So we don't get as many as do take place on private land, but it's fairly significant, and they all have to give us return statements as well, so we know how much they've collected and how much goes to the charity.
I don't want to be seen to stop charity collections, but it would be nice to know if we do get problems with them, because I've never had none, but
Yeah,
I suppose there must be some from time to time.
We have had concerns raised to us about the conduct of people that are collecting with some charities. Some members of the public don't feel comfortable with the fact that people walk with them and try to ask for money, for instance, but the code of conduct is in place to protect against that. And we will, if we've licensed or given a permit to a charity collection, and we do get issues with them, we will then go back to the charity and obviously work with them to see if we can eliminate that happening again.
At risk of sounding like I'm coming in new, now trying to generate work. So I guess I would worry just in isolation, kind of just generating reports on particular kind of single issue items, but without having knowledge of kind of what comes to this committee and when. I wonder whether there's a piece more generally around the service, types of applications that we receive, particular hotspots in terms of complaints, which then may focus our attentions perhaps. So I think your point's really valid, but I would like, I guess, as portfolio holder, not just to kind of narrowly focus on one particular area, but actually if we're doing something like this, I think for me it would be more generally across the piece. And I hope I haven't spoken out of turn being brand new, but I think I would rather it wasn't just isolated to one particular issue and it was kind of more broader than that.
I think you're right. Knowledge is what we're after. And if you're asking us to make decisions, we need the knowledge. If we haven't got the knowledge, because it's charity, we nod it through because that's what we believe in as a council. But we do need to know a little bit of background. That's where I'm coming from. I'm not saying to stop it, God no, but we need to know what is going on in our borough because it's a big borough. As you say, I naturally assume, but wrongly, that we're talking at the top of town, but people go around houses and different things, don't they? So we do. It'd be nice to know whether it's every year or just once in a while you give us some updates on what's actually happening.
I'm more than happy to bring a report back that shows what happened, especially for last year, for 2021. I've just done that. Monthly, I do KPI reports, so we look at what we have coming in, what sort of complaints we have, and that's done regularly every month. So we can do a summary of that and show you everything that's happened last year and bring it back to committee for you. That's not a problem.
Councillor Fillimore.
I just want a bit of information on cost. Don't say anything in here. How much is a permit? I can't believe we give them away free of charge.
They are absolutely free of charge, and we have no jurisdiction to. It's statutory, and we cannot charge a fee for them. Yeah. So.
Councillor Concheccia.
Just wanted to ask you about the checks on the charities and the individuals who are working for the charities. How robust are those? Because you sometimes hear about certain things happening in certain cities or towns as well, where the council or the local authorities find out they've been collecting for something completely different, and sometimes for certain groups that are banned, etc. So how does that happen? Is it quite robust, the actual application procedure?
So the checks on the collectors are done by the charities, they're not done by us. So they will send us in documents to say who is collecting, where they are collecting, how many collectors that there are. But as we said, there is no fee attached to this. So the checks at our end are what is required by us. But we don't do additional checks like we would for a taxi, so we don't do DBSs on them or any of that. We hope that the good charities that we work with will send us that sort of information so we know. But there is only a minimum requirement, and it's for the charities to do those checks, unfortunately.
Thank you. Any further questions? No? Are we happy to accept the document as it stands without any minor amendments?
just with the one amendment that we agreed about putting an extra get-out clause. Thank you.
Thank you very much. So we'll move on to item 8, if we may, review of the work programme.
Okay, so the work programme for this year, I don't have a document for at the minute. This year is those who came to training know that we've had two new acts come out so far this year, and very much the focus this year will be around the taxi and private hire trades. So far this year we've had and it's called taxi, which is obviously wrong, Taxi and Private Hire Disabilities Persons Act, that has just come out. So this is an amendment to the Equalities Act 2010, and it is to stop discrimination against disabled people who are using the trade. So there's a requirement that we're currently working on with IT to better promote those vehicles that we have that have disabled access. We're very lucky within Basingstoke because all of our hackneys are disabled access vehicles. Other boroughs aren't as lucky as we are. So that's a minor change for us because we've always had that within our policy. Secondly, the Taxi and Private Hire Vehicle and Safeguarding Act came out. If you were at the training, you would find that when we get new drivers and renew drivers, there are a number of checks that we do. One of them is the DBS check, but that only checks criminal history. So this new act, there is a national database called NR3 that we've signed up to as an authority, and those that don't end up in conviction are on this database. So if any other authority has refused, suspended or revoked, well done, a application or a driver for a relevant offence that hasn't resulted in a conviction, because not all do, that information is on this register and it's held for a period of 25 years. So this is new stuff that's just come out. Obviously, in 2020, this committee approved for us to move to 6-monthly DBS checks as a load of regulations came out to try and standardise the hackney and private hire trade across the country. A new version has come out, so it's gone from 24 pages to 104. It is much better than the previous version and encompasses more of the things that we've asked for. And those that were there when we had a member of the trade speaking who was asking about things like tinted windows, age of vehicles, admissions, all of those have been consulted on within this document. So it's currently being analysed and it's being led by the Minister of Transport. So she's pushing because she wants a nationalised standard for our trades. It's supposed to be coming out in the autumn, and I can see that there will be some rather interesting papers coming back to committee at that point when we have a look and see what changes that we need to make.
Thank you very much. Any further comments? We have no confidential or exempt items, so unless anybody's got any further comments they wish to make, that brings the meeting to an end at 7:12. Thank you very much, and I congratulate all the COVID